4 in New Brunswick, Saskatchewan, and then Alberta since 2001. And I've worked almost exclusively in education law since 2001, first with the ASBA and since 2018 with Brownlee. And we also have other departments in addition. For example, corporate commercial. We have privacy experts as well, which thankfully I no longer have to do privacy law except at the outset. But in any event, we essentially serve anything that a school board does. We do that kind of work. So that gives you a bit of an overview of Brownlee. Now, in terms of my presentation today, the overview, we're going to look at concerns where sort of unsafe work conditions related to special needs students with severe behaviors in schools. We're going to look at that and talk a little bit about the relevant statutory scheme. I'm also going to consider a recent New Brunswick grievance where significant damages were awarded to 2 teachers. I didn't follow up to see if there was another grievance by support staff, but the facts certainly would have supported one. And we're going to apply some of the facts of that case to our Alberta scheme and also address some practical considerations for school boards that I've run into over the years. Now, how these concerns are coming up, as I said, the New Brunswick case is a grievance. I've dealt with several support staff grievances and several refusals to work by employees, some that have resulted in reports owing to Occupational Health and Safety Act requirements. For example, when there's hospitalization, there's a mandatory reporting requirement. And it's come up in collective bargaining. We now have provisions under the Alberta Teachers Association collective agreement and support staff that specifically reference harassment. Not that the law also would have read in those obligations regardless, but I think there's been an impetus and a focus both by teachers and support staff in terms of school safety and special needs students. So as I mentioned, or I should indicate that at any time, if you have any questions, feel free to send them in. I may not see them on my screen, but I believe Brandy would see them and therefore she can relay them to me. Or if you can just unmute and interrupt, certainly your questions are likely more interesting than anything I'm about to present. So that's an overview. And feel free to, if you have any questions, feel free to fire away, as I said. Now, the grievance that I've looked at, which gave a fairly good background about a severe special needs students, and these concerns are not just in Alberta. They're in Saskatchewan, they're in New Brunswick, and we do work in Saskatchewan as well, so we see some of those from time to time. And the recent matter out of New Brunswick, it was a relatively recent, I think 2024. It was a 9-day hearing. Though the regime is similar to Alberta, the Education Act in Alberta has some different provisions than the similar legislation in New Brunswick has, and therefore they may have had some lesser options than what would be available in Alberta. And in this case, the student behavior that was for the most part examined in the grievance spanned over a 2-year period. It included support staff, teachers, and had repeated physical, mental, and emotional injuries documented in great detail. Now, and they included over 100 health and safety violent incident reports. Similar regime to what we have here. There's approximately 95 incidents of behaviors not tolerated and or serious misconduct, all undisputed. So it's not a question of the child's parents or any staff member or even the central school division indicating that it didn't happen. The incidents were accepted as having occurred. The student on one occasion kicked 2 separate EAs, threatened to bite and hit an EA, stated that the student was going to cut her head off with a knife, and he would sort of make conditional threats to the EA and at times even the teacher what would happen if someone brought a gun to school, intimating that he would do so. On several occasions, he dug nails into staff, kicking, hitting. The repeated threats and profanity-laced kind of comments. He, again, a gun and a bow and arrow, he threatened to use that on staff. And he had access to both weapons. It was known that he hunted with his father and therefore probably had a little more gravitas to the complaints than simply somebody. It wasn't a joke, is essentially how the staff members viewed it. And there's repeated sexual assaults on staff members and repeated statements about a sexual assault to come down. This resulted in multiple lockdowns at the school because the other students weren't safe. And again, we're looking at primarily a 24 to a little more than that month period. Now, the division response to the behaviors included suspensions. There was no expulsion, which again would have been an option here in Alberta. There was an emergency response team, so kind of a sort of a VITRA assessment process is likely the equivalent that most follow here in Alberta, where lockdowns were done. As I said earlier, the incident reports were completed, similar to our occupational health and safety reporting requirements. There were frequent calls to the parents to remove the child. The parents weren't particularly easy to deal with and seemed reluctant to intervene. There were calls to the police. Again, these were some fairly serious matters and serious conduct. And at one point, of course, there's an IPP plan or the New Brunswick equivalent of the same. At one point, they had 2 education assistants assigned to provide rotating support, and eventually 4 education assistants were involved at times dealing with the student on a daily basis. Suspension was rarely used, and again, expulsion, if available, was not in the reason. So I didn't review though I'm a former member of the New Brunswick Law Society, I didn't review their equivalent of the Education Act to see if expulsion was even a possibility. But it wasn't mentioned in the arbitrator's reasons in response to the grievance. So presumably, it wasn't a strong consideration. The principal voiced grave concerns about safety to division office. The principal's evidence was, though there was approximately 25 special needs students in the school, 100% of the resource teacher's time, who was the other griever, was on the one student. So I think the equivalent term in Alberta for the most part is classroom support teacher. There's other terms as well. But the sort of dedicated expert for special needs students was spending essentially 100% of her time with the one student. And as I said, she was the other griever in this matter. Now, there were several injuries, some to support staff and some to the teachers, and workers' compensation responded to some injuries. The employer, according to the arbitrator in this case, violated its obligations by failing to take all reasonable steps to ensure a safe workplace, and further aggravated the harm by placing some level of blame on each of them. Now, I don't know if any of you are Trekkies, and I'm sort of giving my age a little bit, but there used to be Captain Picard would always say, "Make it so." And so that was what division office was sort of doing with the school. There's a plan. It's a great plan. Just make it work. And essentially what the arbitrator stated in this case, the students' exceptionalities were well beyond the scope and expertise of nearly every educator or specialist involved. So they did throw some, whatever expertise they had in the division at it, and it was suspected there was FASD along with a number of fetal alcohol syndrome, along with autism spectrum disorder to some extent, but very, very violent behaviors. Now, in this arbitration, the arbitrator awarded $45,000 to the principal. She essentially retired about 2 or 3 years early and had retired prior to the grievance. These are rather high damages. In New Brunswick, these numbers would be, if we were to translate them into Alberta, these would have been significantly higher in Alberta for similar conduct. And $35,000 to the classroom support teacher was also done by the arbitrator, was awarded. And it was to compensate for injuries arising from the employer's breach of its health and safety obligations under the safety policies, the equivalent of the Occupational Health and Safety Act, and the collective agreement. So it's not inconsequential. And as I said earlier, the damages likely would have been higher had this occurred in Alberta with similar circumstances.
Yvonne, we do have a question. Lyndon's asking, he'd like to know what all reasonable steps are. Like, what would all reasonable steps mean to this?
It's a case-by-case analysis, and although the arbitrator quoted a portion of the Occupational Health and Safety Act equivalent in New Brunswick, we have similar legislation. And so you look at what are reasonable steps in a given circumstance. So if we're talking about for example, a janitor working in an office, well, you give them WHMIS training. You explain to them the processes, what not to mix together. And then if the person fails to follow the training they've received and mixes two chemicals together, which is a matter I dealt with where a janitor had been given all of the training, had all of the steps, and despite being told to rinse out the bucket before adding a particular chemical, she thought it took too long and she nearly killed herself by mixing chemicals together that created a form of chlorine gas. So reasonable steps in a given circumstance is dependent on the situation. So in this case, basically the school division didn't consider removing the student. And clearly at some point in time, the plan where a division office kept saying, well, the plan's great, keep doing it. Well, clearly the plan wasn't great. It wasn't working. And they did throw some expertise at it, but there's other steps that could have been considered. And the arbitrator didn't spend a lot of time on that. They were focused mainly on the conduct that occurred, the injuries that resulted, the fact that reports were made by the principal and the teacher to division office, and essentially division office would say, just keep doing what you're doing, which clearly the arbitrator felt was unreasonable. Does that answer your question?
Thank you, Lyndon. Feel free. Oh yeah, Lyndon says yes. Thank you.
Now, and just to take this matter, and I'm going to sort of apply the facts from this matter to Alberta. So the Education Act provides the following rights. So inclusion is a requirement, and that's I cite the preamble there. But there's also other obligations, and it's kind of a strict liability obligation under Section 33(1)(d) that goes likely farther than what does the Occupational Health and Safety Act, because each student and each staff member must be provided by the division with a welcoming, caring, respectful, and safe learning environment that respects diversity and fosters a sense of belonging. And then 33(1)(e) says you got to provide a continuum of supports and services to students that is consistent with the principles of inclusive education. So it's clear that inclusion is the starting point. But there's also Section 2 of the Education Act that talks about the rights and obligations under this act must be reasonable. So there's a reasonableness element both for employees and for students. Now, the obligation for a special needs student to attend a regular classroom largely flows from the case law in addition to human rights legislation. And the Supreme Court of Canada in Moore versus British Columbia basically said that special education is not a dispensable luxury, but a fundamental requirement for providing meaningful access to education. The unanimous decision highlighted that school districts must accommodate students with disabilities to prevent discrimination, ensuring they have equal opportunities within the public system. So all of these principles, in addition to the principles in the Education Act, are sort of what guide the your school divisions and frankly, even in the New Brunswick situation, it's a common law right to attend school. And so the right can only be limited when necessary and in accordance with the Act, which we're going to review here. Now, under Moore or any human rights legislation, undue hardship is the legal limit to the duty to accommodate. So you're a special needs student or you're an employee with special needs, the obligation to accommodate, the duty to accommodate is to the point of undue hardship. And this means we're talking about excessive or intolerable burdens and may include significant financial cost, serious health and safety risks that make a requested accommodation unreasonable, and it requires substantial, not minor disruption or expense. So in this situation, it's safe to say, though it wasn't a human rights matter, the division was saying we have a duty to accommodate. And what the arbitrator was saying in New Brunswick is, yeah, but you had reached and exceeded undue hardship, which was what was imposed on these employees. So again, the student's rights, yes, he has a duty to be accommodated, but it's to the point of undue hardship. And the division went beyond that.
We do have another question, Yvonne. So how do the Education Act's expectations for safe, welcoming schools intersect with OHS requirements when student behavior affects staff safety?
There's two regimes. One, essentially, employment standards can do an investigation if they receive a complaint. That's independent of the Education Act. But the Education Act grants rights, kind of like to both students and staff members on essentially a strict liability basis. There's a decision out of BC called Jubaran. It went before the Human Rights Commission in BC. Just to give you an example, they have similar legislation to Alberta's Section 33(1)D in their Education Act. And in that case, Jubaran was the target of homophobic slurs on repeated occasions. The school on each occasion suspended or expelled the kids that did that. They did some training about inclusion and acceptance, but despite all of their efforts, Jubaran was not provided with a safe and caring learning environment, and therefore the commission, right up to the Court of Appeal in BC, awarded damages to Jubaran. In Alberta, I was involved in a human rights complaint where a student engaged in harassing and bullying behaviors directed at a teacher. We had to set up a sting operation and eventually determined that the online harassment by the student of the teacher, sent home a homework to be done remotely. Back in the days when IP addresses were more fixed, so the student had to submit an assignment from home, and then on the same night used their computer to send further horrible sexist and racist comments to the teacher. And we were able to determine then that it was in fact the student, that because the homework and the harassing conduct were both from the same IP address. The student was expelled. The conduct continued despite being expelled, and a human rights complaint was filed by the teacher. And even though the school division did not discriminate against the teacher, did the capital punishment in the school law sector, which was expulsion, the teacher was not provided with a safe and caring working environment, and the Human Rights Commission ordered damages in that case. So you did nothing wrong, you expelled the student, you supported the teacher, you did what you could, but that right was violated. So now under occupational health and safety, had she filed a complaint, likely and she may have, I don't recall, but the teacher, the occupational health and safety people may have said, you took reasonable measures to protect the teacher. You did a sting, you got the student out of the classroom, you provided support and training to the student and the teacher, you gave leaves to the teacher, did whatever you could. So we likely would have met that test, but we didn't meet the test under the then School Act relative to the safe and caring learning environment. Does that answer your question?
Thank you.
Now, in terms of undue hardship, there's sort of additional factors that are considered. You look at the size of the employer organization, the available resources. So a rural school district in Alberta with 150 teachers versus Calgary Catholic or Edmonton Public would not sort of be held to the same standard. You would look at some of them would be the same, but others you'd look at the resources. You may not have multiple different options for expulsion of a student, when we're talking about undue hardship and doing that analysis, you must prove the undue hardship with objective evidence. So how do you do that? You gather information. So in New Brunswick, all of the incident reports. You assess the financial cost. They had 2 EAs assigned at one point. They went up to 4. The behaviors still weren't addressed. You evaluate resources. Throwing another, going up to 6 EAs likely wouldn't have assisted. You also analyze operational impact. So look, the school shut down several times for a few hours in lockdowns because of this kid's behavior. So you're interrupting the education and the entitlement to education of the other students. You also have to evaluate health and safety risks. So that's part of your undue hardship analysis. And you document everything, including options considered. And that's one thing I didn't see in the arbitration case involving New Brunswick is other than there was repeated times where the principal talked about, the student not being at the school, and the division kept coming back, well, inclusion is required, you have to accommodate. And again, there was no suggestion that an undue hardship analysis was made. Now, in terms of occupational health and safety, so when you have there's a dual track process, or even more than dual, I guess, in some cases. You have the IPP plan that is usually developed for a special needs student. That addresses educational needs. There will be strategies that may address some of the aggression, but you also have to determine what measures are necessary for a safe work environment relative to a particular special needs student. So in this case, there was one EA that gave evidence in the New Brunswick matter where she talked about getting her hair pulled, and one of the strategies provided was to wear her hair in a certain manner, but she refused to do so. And there was also a suggestion of wearing Kevlar because I think there was biting and pinching, and the EA said she wouldn't have worn it even if it was permitted, which is sort of in that case, if the hazard assessment indicated that there's a risk and this is the only risk, that should have been addressed, frankly, from a disciplinary perspective, in the sense that there's safety requirements that are necessary to work with this child and you're not following them. So the obligations in Alberta: employers must ensure worker competency, safety, while workers have the right to know, participate, and refuse dangerous work without fear of reprisal. So in the New Brunswick case, there's no talk about either the principal or the teacher or EAs refusing work. There's talk of injuries. There's talk of other many injuries and mandatory reporting. But there was, and it may not be, again, I'm rusty on my New Brunswick law. They may not have the equivalent or had the equivalent at that time of refusing unsafe work and not being financially penalized. That just wasn't in the reasons.
We do have another comment. So it says we have PPE, nonviolent crisis intervention, individual behavior plans, and support staff in place. What other preventative or intervention strategies are recommended when students' behaviors pose that safety risk to staff or other students?
Well, there's also, and I'll touch on it later, but given the question is now, you also have, and that's why I did the duty to accommodate stuff and undue hardship. You also have in Alberta a complex needs tribunal. So if you're, there are instances where needs are so severe, or the special needs behaviors and the behavior management plan isn't working, that you may then move towards a complex needs tribunal and say, look, and that's why the documentation is important. Here's the IPP plan. Here are the strategies. Here's all of the incident reports pertaining to this student. We don't believe we can safely provide an education program to this student in this setting. And you ask the tribunal either for additional funding to address the special needs of that student, or that they be directed to a particular program that can deal with the safety issues that that student presents with. And that's through a complex needs tribunal. And we'll review that in more detail, but that is where the rubber meets the road in Alberta. So in the New Brunswick scenario, in the same set of circumstances, probably within 6 to 8 months, you might have been in front of a complex needs tribunal saying, look, here's what we've done. Everything's documented. Here's the strategies that we've tried. We can't provide a safe work environment for these employees, nor can this student safely attend school. And ask the complex needs tribunal either for funding or that the student be directed to a more specialized program, for example, at a larger division that might have a program that could deal with that student. Then the complex needs tribunal could make a damage award or a direct payment by the resident school board to the receiving school board. Here's what the cost is that should be paid. And I've been involved in some of those as well. So I won't review the OHS supervisor obligations, mainly because I trust you know them quite well. But one of the, and certainly there's times where the obligations conflict, and that goes to the earlier question. And one of the things they didn't do in the New Brunswick matter is sort of address, they took a top-down approach. We've done the plan here at central office, and you people down at the school level just deal with it, make it so, make it work. So there wasn't a lot of input. Now, there was also some insubordination in that a worker, one of the EAs, refused to follow a safety plan. Clearly, the arbitrator didn't express an opinion on it, but in cross-examination, the EA did indicate even if, pardon me, though I was offered, it seemed to be, were you offered protective measures, and if you had been, would you have done it? And she said no. So I wasn't sure if it was no to both or just the one. So in this case, if you have a plan for safety, and I've had this happen on a few occasions where the worker support staff says, I'm not going to wear the Kevlar, it's uncomfortable. I'm not going to wear the spit guard because it doesn't look good. I don't want to tie up my hair and put a cap over it because the kid's a hair puller. And if the risk is real and the plan is reasonable and the employee refuses to do so, you likely have to address that from a disciplinary perspective in the same fashion as you would for any other form of work where there's a danger and there's a measure to address the danger and the worker's refusing to do so. And that's under the code, Occupational Health and Safety Code, where, look, if these PPE are necessary and the employee is refusing, the employer has a duty to intervene. Now, in terms of the student safety plan, of course, like I said, there's kind of a dual track. One is programming, educational programming with some measures to address the risk behaviorally, but then you likely need to address like in the situation for the New Brunswick situation, they should have had a student safety plan in considerable detail to address the risk regarding the behavior concerns, and know if there's triggers and antecedents or prior instances, address prevention and intervention strategies to support the workers and also the student safety, so we don't have 20 lockdowns a year. And you need clear communication procedures for all workers, teaching and non-teaching, whether permanent or occasional, and in some cases, emergency communication procedures for all workers. So again, to give you an example of a student safety plan that I was involved in, as a result of a mandatory reporting. So I got in at the back end. The client retained me to address and assist in responding to a complaint. A teacher had been hospitalized or taken by ambulance to the hospital as a result of an incident. So they sent me all of the documentation, which again was forwarded because it was a mandatory reporting situation owing to hospitalization. The process involved a student that was on the spectrum, and there was and again, very excellent plan, very well detailed. The student was now 15 years old and had been in the division since kindergarten. And of course, the plan had evolved every year and changed as the student got older. At the time of the incident, I think he was 14 or 15. The plan, again, there was an IPP plan about the educational piece, and then there was a safety plan that was put in place that involved the teacher, principal, vice principal, the learning support teacher, and I think there was a psychologist as well. And the EAs, it was a unionized environment. The EAs were also involved in developing the plan. Training was given. There was 3 EAs assigned to the student, one that sat on the left of the student, one on the right, and one that was waiting. They had a 30-minute rotation basis. And in the meetings prior to the school year and on 1 or 2 occasions during the school year, this one would have been mid-school year, so they only had one sort of update meeting that I can recall. And so the teacher was told, look, here's what he's done in the past. His triggers. This student got off on violent conflict, and sought it out whenever he could with other students and with other teachers. And he would set traps. For example, he would try to drop an eraser or a piece of paper, and if somebody went to pick it up, he would then use that as a means to attack someone, or as a basis to do so. Teacher was fully informed. So that's precisely what happened. The student dropped something on the floor. I don't recall what. The teacher came forward, didn't follow the plan, didn't follow the warnings, picked up the whatever the student had dropped and tried to place it on his desk. And the student was in the process of doing work. So the 2 workers didn't see him in an agitated state. And then he flipped his pen quite quickly and jabbed it into the thigh of the teacher, like 2.5, 3 inches deep into his thighs, and extremely painful. So once the employment standards reviewed all of the circumstances, the training given to the teacher, the reports made, they determined that that was a reasonable process. It was well documented. There was appropriate training, and essentially human error was what occurred. So there was no violation. And in fact, they thought the plan was quite robust. So relative to any student safety plan, and that was one of the key points that when I read the safety officer's decision, all school board workers were involved. And there was periodic oversight and review by school administration and the people involved. In that case, there was also parents and guardians, because part of the IPP plan indicated or showed that evolution. Initially, he had 1 EA, and then eventually 2, and then eventually 3, as he got stronger and more difficult to manage. There was also, in that case, some community interventions, but and in that case, whatever community intervention wasn't relevant to the situation I was in, but it showed that the division was attempting to address the behaviors not only on a day-to-day basis, but also from a learning and societal perspective to move forward. And as I said earlier, and that was one of the things in the New Brunswick case that we didn't see. They didn't talk about reviews of the safety plan. They didn't talk about updates. Division office would just say the plan's great, just make it so, because they should have been revising it, learning and improving in the interest of student and worker safety. Also, when should the plans be reviewed? Again, periodically, or when there's a change in behavior that could increase the potential for a violent incident or risk of injury to self or others. Conversely, if the student behavior is improved, you might reduce some of the measures that are implemented. And whenever there's an incident, there should be a review of the plan and an assessment. And I would suggest at least annually. As I said, the one that I was involved in, it was a very high needs violent student, but their plan was reviewed at the start of the year and periodically. I'm not sure if it was once or twice during the school year. And certainly whenever there was a new teacher that came in, the plan was reviewed by school administration with the teacher and given the background. And I trust the teacher that was away for several days dealing with the injury, the substitute teacher would have been fully informed of the situation, which obviously would have been necessary.
We have another comment. So question is, how do we balance OHS requirements with privacy rules? And are there any clear do's and don'ts that we should follow?
Well, from a privacy perspective, it's the guide is need to know. Does the janitor need to know that a student has a safety management plan? Not unless the janitor knows to not let students out at a certain time. That might be to the extent, we have a runner in the school, therefore there's a particular door that must be locked or something like that. The janitor might need to know that. But does he get to know the diagnosis and all of the other strategies? Certainly not. So and again, it's a case-by-case analysis. If you have a runner in the school and you have an EA that's a substitute that comes in, a teaching assistant that's a substitute and comes in, and hey, the student you're working with has here's the tendencies, here's the strategies you need to deal with it. Probably all of that detail is necessary. Same as a substitute teacher that comes in is dealing with a student that has special needs. They likely have a need to know that information to manage the class. And if there are certain triggers that they should be advised which triggers to avoid. And if there are certain risks, here are the strategies we use to address those risks. Does that answer your question?
Thank you. Siju, just make a comment if you have any other questions. Thank you.
Now, I mentioned earlier about discipline when safety measures are not followed. And I've had one grievance that was resolved once the union saw the training that was implemented. So here's the special needs student you're assigned to work with. Here are all the tendencies. Here's the safety measures that are necessary to address the risk. It included personal protective equipment, and the employee refused to wear the various. I think one was a spit shield, and I think there was some Kevlar, and it also involved a cap because there was hair pulling, spitting, biting involved, and it was like a grade 2 student. And the employee refused to do it, and therefore tried to grieve the fact that it was, that I should get paid for a refusal to work. The grievance was resolved without payment once the union saw the measures. And again, whether it's that member that had to work with the student or the next one, the same strategies were employed, and the next employee managed to implement the plan without, there was challenges, but the safety measures were appropriate. That doesn't mean you don't revise them, but when you document it and show what was done and why, that can address those particular types of grievances. And again, under the code, you're required to do so. And again, just more on the code here about the use of protective equipment, PPE, that someone referenced earlier. Yeah, and again, I'm not going to review that anymore. I think that's pretty clear. Now, as I said earlier, revise the plan as required, not when convenient. So we only do it annually. Look, if there's a safety risk, you likely need to revise it. If the safety situation arose yesterday, and we've had the recent shooting in BC, and I think I've had 3 or 4 VITRA situations here in the last 10 days with similar types of allegations or concerns. Again, you need to address things as they arise and not when convenient. and if there's any incident that occurs, although they did report quite well in the New Brunswick situation, there was a number of incidents. You want to make sure that in this scenario that in Alberta, your occupational health and safety reporting requirements are met, and you want to ensure your training is done, as I've indicated. Ensure redundancies in the event of absences for temporary teachers and substitute teachers or EAs. And you want to ensure you're meeting your responsibilities. And that being said, if the employee says, well, I'm not going to wear this because whatever reason, and the reason is will not address the risk, or for example, if the behaviors are the same and the strategies are to wear your hair under a cover, and the employee refuses to do so, you need to consider whether that employee should be allowed to work with that student, because it then becomes a safety issue for which you can be held responsible. And as I indicated earlier, involve the union if you have a union. And on numerous occasions, when we get the union involved, we put together the safety management or review the behavior management strategy or the safety management plan that resolves the situation. I've had an instance where a refusal to work occurred on a claim of asbestos being possibly in the building when the previous year, involving the exact same employees, a full remediation had been done. So that likely was an unreasonable refusal to work. But nonetheless, the allegation was made, a review had to be conducted, and it was done in fairly short order. Now, whenever a concern arises, of course, if there's, and I've had situations where boards voluntarily report to a safety officer, here's the measures, are these okay? They never called me back, so I assumed it was resolved, and the grievance went away, so I trust that the situation was resolved. And again, as some of the investigations I've been involved in confirms that the measures are appropriate, the worker no longer can refuse the work because you've put in place reasonable measures. There can be an appeal of an occupational health and safety finding, so you may have to delay certain things, but during that process, the worker can legally be required to return pending an appeal. Again, workers are protected from reprisals for legitimate good faith refusal, even if work is found later to be safe. So there are some protections under the Act, but as I said earlier, the example of when a remediation had been done at the exact same work site, exact same job, involving the same workers, that was likely not a good faith refusal. So there could have been discipline. I don't think discipline was issued. There was no point, but there could have been discipline because the complaint or the concern was unreasonable. Now, another thing that I've seen arise in certain situations is where support staff, at times there's seniority rights, and you want to ensure that, and usually, sometimes, or not usually, sometimes the seniority rights allow a more senior member to take a particular assignment in advance of a less senior member. But you also want to ensure that there's an equitable distribution of the work so that not one or two employees are doing all of the tough cases, or you rotate them out whenever possible.
But I have another question here.
Yep.
We have have we had a ruling from Alberta OHS on refusal of unsafe work in the situation? If so, what was the ruling? Having had a report submitted to Alberta OHS, it was not finalized because the student was moved to another school and the employee pulled their complaint to Alberta OHS. Therefore, there was no ruling of whether the workplace was safe or not under Alberta OHS.
So if you're asking, should the salary be paid during that period when there was no ruling, and assessing it, I based on the current information I have, I think it would have been reasonable for the employee to refuse the work and to be paid. There was no finding, adverse or otherwise. I assume it wasn't a bad faith complaint. Now, with all of that, so the student withdraws or moves to another school. That doesn't mean that the work was safe. So in that scenario, I believe they would be entitled to be paid for their salary.
Oh, sorry. He's saying no. Has Alberta OHS ever ruled on a complaint?
Oh, well, I've had numerous rulings for
Yeah.
boards I'm involved in. Their cases are reported. In that specific fact scenario that you've referenced, not that I'm aware of. That's not to say it hasn't occurred. I'm not aware of it.
Thank you.
And now there's also requirements for incident reporting to your Joint Health and Safety Committee, which some boards forget about. But again, you need documentation of each step to ensure your processes comply with legislation. You then ensure your structure is respected. I've had situations where only employer side representatives attended the Joint Health and Safety Committee, mainly because the workers refused. And I've had OH&S say, look, the workers must be there. So hold the meeting and direct them to attend. And you got to follow the purposes for the Joint Health and Safety Committee. The meetings are to occur quarterly, and the duties include hazard assessment, reviewing inspection documentation, and training. Currently, there's two main risk assessment processes that I'm aware of. The CIVA, supporting individuals through value attachment, which numerous boards are starting recently, and the VITRA process, which some use both in combination and some use one over the other. Now, as a starting point, not all behavior management strategies or plans will be successful, and so you must be prepared to revise your plan. Now, insubordination, refusing to follow a reasonable plan, that's not what I'm talking about. I'm talking about the New Brunswick situation where we have a beautiful plan, make it so, and clearly the plan wasn't working. Now, in New Brunswick, one of the key points, the employer took a top-down approach. We didn't see any evidence of consultation with the front line, or other than the frontline workers, the principal, the teachers, and the EAs reporting to division office. We didn't see any input or change in the plan as a result of those reports. There was no talk of the union being involved in developing or revising behavior management strategies. That's something I would have recommended. Your member says there's a risk. Okay, great. You sit down with the member, and if you can't agree on a risk, pull in the union saying, look, we're trying to develop a strategy to deal with these risks. And certainly if the union agrees with some of your risks and the employee doesn't, that doesn't mean your plan is good, but it is certainly a good indicator. And again, there was no information, or I don't know if there's a Joint Health and Safety Committee requirement in New Brunswick. There wasn't when I practiced there. There might be now. I don't know that, but there was no information about that in the agreements. And in that case, the employer seemed unwilling to consider a revision of the strategy. And the student attendance at school was seen as more important than staff safety, which to me, there's concurrent rights. And at times in Alberta, we talked about the reasonableness thing. There other tools weren't considered. It might be that there's a legislative gap there. Could have been a lack of resources. It could have been a failure in communication. But in any event, be prepared to revise a plan that is failing. You get 100 incident reports and you're following the same plan, you've got a problem. Yeah, and I talked about this earlier, the pen jabbed into the thigh. So that sort of confirms the process here. Now, if we, yeah, so that again, that I already reviewed that situation, but here's just in writing. Now, and in that situation, as I said, several meetings occurred, some periodic, some post-incident, and all of the same details that I referred to earlier. Won't go over that again. And the Occupational Health and Safety Officer finding had assessed the risk appropriately, had a reasonable plan, trained employees appropriately, and conclusion was that the employer complied with OHS. So that was the outcome of that one. Now, I talked about the Complex Needs Tribunal, and there is it's not frequent. I've probably had it come up a half a dozen times in 24 plus years. But I've assisted boards in making the referral. I've never appeared before the board. I believe it's just a written review. But again, you would need documentation to support. You sort of can't just show up with one IPP plan with no incident reports or no information saying we can't provide an education to this student. You would need documentation to demonstrate what strategies have been tried, what diagnoses are present with this student, and the documentation has to be clear to show that your school division cannot, or this school cannot provide that student with an education plan in a safe manner. Now, in terms of the takeaways, do not lose sight of what is most important. Again, the safety and well-being of students and staff members. If you can't have a student safely attend at a school or staff members do their jobs without frequent risk of harm or risk of harm without any strategy to address it, then you've got to revise your plan. But you must adopt a due diligence approach. And again, whether it ends up in front of a human rights tribunal for a claim of discrimination or a complaint with an OH&S officer investigating, you document the measures taken to ensure student safety. You document the measures taken to address the needs of the student. I realize that's more on the educational side than on the safety side, but the two are equally important. Ensure that incident reports are completed relative to any problematic behavior, and it is documented. There is a document. Make sure there is one, not a verbal. And under the code, if an employee refuses to implement a safety measure where it's clear that it's necessary, address it from a code perspective and from an insubordination perspective, like you're hereby directed to do the following measures. And again, you would cite the code because it's the PPE is necessary. There's always the option of a complex needs tribunal request, but again, all of the measures would have to be in place to be successful. In due diligence, you show you did your work and what worked, what didn't work, and revisit work plans as required. You also need to debrief with the Joint Health and Safety Committee and get their input. Union input can be invaluable. And if you've done an undue hardship analysis, that likely wouldn't be on the safety side, but that likely would be something where you may assess whether, for example, if somebody can't wear a particular PPE, you would have to address that from an undue hardship perspective. For example, if it's a religious accommodation or the screen, a spit screen causes issues with breathing, you might then have to assess it and undertake a duty to accommodate analysis. It's rather exceptional. I haven't seen that one yet. We did have, I'm sure all of you had a number of those during COVID with masks, where many of those claimed inabilities to wear masks were debunked fairly quickly. And again, with respect to any safety measures, you must ensure training, that the measures are being respected, and discipline if they're not being followed. And for any letter of discipline, there's kind of three that I sort of recommend. Again, a verbal doesn't count. You can talk about a letter of expectation, a letter of caution, a letter of reprimand, a letter of expectation being the least, sort of the first step on the continuum of progressive discipline. And the more severe being a letter of reprimand. If you're at a letter of reprimand, there's likely going to be a warning of termination if the employee fails to follow the safety measures that are necessary for dealing with that particular student's risks. And you need to ensure everyone's on the same page in terms, and that doesn't mean there has to be consensus, but if a measure is taken, and the people need to be trained what the measures are, and that includes everyone from education assistants, teacher, principal, vice principal, learning support teacher, or any other equivalent expertise or higher level expertise you may have in the division. And of course, your occupational health and safety expertise for the risks that could arise. Any other questions?
Thank you so much for all the information. We do have one. We have nonviolent crisis intervention and we offer other professional development. Are there any other essential safety training that our boards can offer?
Uh, Many of you use Hour Zero,
Yeah.
and that's one of the training methods I'm familiar with. But you also need to ensure. Well, here's literally did a couple today, occupational health and safety letters. So when an incident arises uh, where there's a risk of safety, whether it's sexual harassment, physical violence, I always recommend documenting that the supervisor document that here's the incident, we've received your report, here are the measures that we've implemented at this time, pending our further investigation or review, because the ones I sent out today were at the initial stages. And then you could then also include any relevant admin procedures about reporting. And if it involves threats, for example, I've had numerous situations where parents threaten staff members. It might be a situation where you indicate to the individual, look, you may want to consider meeting with the police, getting a peace bond, and certainly the division would send a cease and desist letter, issue a ban under the Education Act, and also a no trespass letter pursuant to the Petty Trespass Act. Those are all supports you can do. I've had instances where employees are refusing to file a complaint and only make an informal complaint in a safety sensitive situation. And depending on your policy framework, if it's complainant driven, you may not be able to act. Whereas you'll want to then send a letter to the employee. You reported this without additional information. We're unable to take measures to address your safety issue. We've recommended the following. And then at least then you've shown you've done your due diligence and the employee is refusing to file a complaint.
Thank you so much. We are running up to 1 o'clock now, so I'm just going to stop recording.